Hello everyone, Namaskar and welcome to today's discussion about Insolvency and Bankruptcy Code, which is focused towards the industry of real estate, housing and construction. This panel, which is very esteemed and has a lot of knowledge and experience in Insolvency and Bankruptcy Code consulting, Insolvency and Bankruptcy Code legal aspects, Insolvency and Bankruptcy Code processes and systems, and also nuances of handling various stakeholders, including home buyers, bankers, and promoters, and all other types of stakeholders like operational creditors and financial creditors, is going to answer few of our questions which we are bringing in this series. This is just a starting video which is going to be instigating thoughts in your mind with respect to insolvency and bankruptcy code for this industry, and we will take it one step at a time. Maybe we'll have 2 3 videos on this topic after a point in time. So welcome CA Hemant Mehta, insolvency and bankruptcy expert, and has been in CIRP for multiple such real estate construction and housing projects in consulting as a resolution professional and as an advisor in various cases. We have Devarajan Raman ji. He is also a lawyer, company secretary, and an expert legal advisor focused on stakeholders like home buyers, bankers, and is very good at practical understanding on how to resolve the matters and how to handle transactions in the scenario of CIRP. And of course, we have Mr. Shanti Patel
Thank you.
in finance and has been into construction and real estate for so many years and has been focusing on deals with respect to specifically real estate CIRP processes or resolution situations which we are facing nowadays. Lot of developers and builders are coming into this trap nowadays and wanting to solve this problem with respect to their own debt situations and also the situations of their principals or their contractors. And we feel that it is critical to discuss their experiences of these experts in the panel so that we get a lot of insights. We will take questions for each one of you. First question, Hemant bhai, to you. You have done a lot of insolvency cases, and I know that you have handled projects which are amidst completion while the company goes into insolvency. What is the practical way in which you handle such situations where the projects are ongoing, money is not there in the company, and the situation is really difficult, and still you see a lot of home buyer faces who are wanting to solve their problems. They have paid part of the money or maybe full money and waiting for getting their homes. Let's start with you, Hemant bhai.
Yeah, thank you, Mitesh ji, for inviting me here in this forum. And I would like to say the scenario in which home buyers are waiting for their homes. They have already invested their lifetime earning in the particular project, and they some of them might have been taking the loan also. They might have taken loan, housing loan, from the bankers or the banking companies, and they might have already sold their home, existing home, to purchase the new home, and they might be staying in the rented premises and paying the rent as well as. So there are two outgoings. One is rent and one is EMI. You know, in this scenario, people are waiting for their home, dream home, for more than 8 to 10 years. So we have already come across such situation where they were waiting for the home for 8 to 10 years. There was no any hope for them to, revive the project. But anyhow, when the company has already come admitted as a CRP, uh, we have got a JV partner who was, kind enough to go to NCLT Honorable, and Honorable NCLT has already granted permission to go ahead in the project. And with the amount of receivables which were there in the, the particular project, we could be in a position to match that receivables with the work which is pending in the project itself. There were about 4 towers of 9 floor each. Now, in few of the towers, there were only 4, 5 floors were constructed, and everything was pending. And only RCC work was being done. So, in that situation, Honorable NCLT was kind enough to permit me as an RP to go ahead in the project and complete the project with the help of financial help and because my CD company was itself having a lot of technical staff and the CD, matlab the company which was under insolvency itself had all the engineers and know-how. So we tried to complete with the help of the staff in the particular project, and we could be in a position to complete those 4 towers of 9 floor each and handed over to about more than 400 home buyers, their homes, dream home, with the amount of receivables and all that. But there were a lot of challenges, like challenges from the political leaders who had already initially opposed the entire project. Challenge is to pursue the home buyers. It was the biggest challenge because home buyers were not having any confidence that when they are suffering for 8 to 10 years, there will be somebody who will be coming to the project and will be completing the project. So calling the meetings again and again, and we requested our joint venture partner to invest initial amount so that work can be started and they can see the progress in the project. And accordingly, they have agreed to, after step by step, they have agreed to contribute for the receivables which were there in the project. So accordingly, we have completed all the entire project. The challenges from the unpaid vendors, they were also there on the queue that they have not been paid for the earlier dues. But anyhow, we had a lot of rounds of meeting with them. And then we requested them that you currently whatever bills are outstanding will be definitely paying. But out of the earlier outstanding, we may not be paying so quickly. But they had agreed for the sake of 400 home buyers. And accordingly, we could be in a position to complete the entire project. And we could be in a position to settle all 400 home buyers with the occupation certificate as well as formation of society, and even the society formation was completed. Everything has been handed over to them. So likewise, we had completed the project.
Hard work, lot of persuasion, and combination of legal knowledge, NCLT follow-ups, and multiple angles from negotiation to deal making to thinking through the process to making sure that nothing goes wrong, and doing it in non-cash environment, completely in the control of the government and completely in the control of the bank is a very big challenge. Good. I think all the home buyers will be very happy and would be blessing you for what you have done, Hemant bhai. We will take up the next question to Devarajan Raman. Sir, I want to actually find out or want your guidance on why typically in real estate situations or in the situation of these kind of housing companies or in the situation of construction companies, why typically they go into first of all the insolvency situation. Can you give few ideas or thoughts on what actually goes wrong and why this happens with them?
See, the point is like this. Each project gets into difficulties for various reasons. The reasons could be manifold. But let us look at a few reasons. From a pure difficulty point of view, in case the DP changes, the plan changes, there could be issues where the project becomes unviable. That could be an issue. There are issues where suddenly the airport authority reduces the height and then there's a viability issue. But typically, most of the projects that have gone into difficulties is basically because of over trading by the promoters. Like they start a project, the money collected doesn't go into that project. They try to start another project with that money in the hope that they'll be able to sell more homes at a better price and make more money, and they get into difficulties, into a very serious liquidity situation. And in a real estate project, when you get into liquidity situations, the cost moves up exponentially. And when the cost moves up exponentially, you are in difficulties, you're not able to complete the project. So these are typical scenarios that we have seen in many cases. Now, those things were much more prominent, say 10, 15 years ago. But with the advent of RERA and with the advent of IBC, things have changed. RERA has tried to streamline quite a bit. So now the home buyers are protected in a way that the entire details of the project is available. There are restrictions on the way the money that is collected has to be used. And these are definitely making a lot of differences when a home buyer wants to buy a project. Still, I wouldn't say that the home buyer is 100% protected, but definitely the risk of buying a home in a building that is under construction is much less compared to the earlier times. So that is one positive development that has happened. But yet, what we need to understand in all this is that till there are challenges because the legal system works slower than anticipated. Even when a home buyer gets into a RERA kind of a situation, it takes time before he gets his orders. IBC, though much better than the earlier system, still takes time. Average resolution doesn't happen in the 180 days or 270 days. It takes about 3-4 years. But compared to the scenario existing before IBC and RERA, things are much better. Now, it is what we need to understand is that the method in which things, like Hemant Bhai said, how we resolved to give 400 home buyers. We need to understand that whether it is home buyers or any other creditors, we are dealing with the unhappy set of stakeholders as a resolution professional. So when you're dealing with an unhappy set of professionals, managing them becomes most important because you are facing headwinds from all directions, right? You have not done anything, but you come in the place of suspended management and all the ire and the anger is thrown on you. You need to manage that situation, convince the home buyers to see that they remain together as a flock. Because we have seen that home buyers also have internal differences between them, which also creates a problem in resolution. Typically, you see that home buyers don't come together as a group and vote, and they don't act in a concerted manner. This also weakens their case in NCL. What happens is that the judges say you are 100 home buyers, but 20 of you vote, you're not interested in your house. So these kind of situations should be avoided. The home buyer should be educated. So on one hand is the difficulty why the project is getting into a situation. The other hand, how the home buyers needs to act to resolve it is something that RP has to manage and do a balancing act to ensure that they get their houses at the minimum additional cost, because that is one big issue that comes up in most of the cases. So the moment a project gets into difficulties, as based on your question, the faster you try to resolve it, the lesser is the burden of the home buyers. That's all I want to say.
Right. This is very interesting, and there is a lot of learning in the experience that has been shared here in terms of what are the difficulties, how it happens, and what is the solution. How fast the faster you solve it, the easier it is, and the lesser is the burden and lesser is the tension to solve it. So over a period of time, I think the IBC process will actually become faster, and we will see the time when things are moving in right direction and at the speedier way. The NCLT and the courts, the CA, the bankers, everyone work in tandem and do as a teamwork and solve these problems. Sir, I want to know one more thing. There are hundreds and hundreds of home buyers in multiple projects in the CIRP CD, that is the corporate data. So in such situations, how do you handle so many home buyers, and what is the mechanism given in the Insolvency and Bankruptcy Code to manage it, and what are the rights and powers of the home buyers in such situations? It is more like a legal question because you are a
Yeah,
legal.
see, the point is what we need to understand is that the Supreme Court with the Chitra Sharma judgment has given a pride of place to the home buyers. Article 21 of the Constitution talks about right to life. So the Supreme Court has equated the right to buy a house to that of right to life. So that is a very big move that Supreme Court has done, and that has changed the position of the home buyers vis-a-vis others in respect of a resolution under CARP. Now they are a separate class. They've been made financial creditors, a separate class, and the COC as well as the NCLT are very, very keen to ensure that their problems are resolved in a particular resolution. Now, it may not be that all projects have home buyers. There could be 10 projects in a particular real estate company where 3 is having home buyers, others don't have. Then the complexities are much more. The resolutions are different. The economics for a resolution applicant coming in is very different. It has to be balanced. But generally, the priority is to ensure that the home buyers are given a house rather than their money being refunded. The reasons are very simple. In most of the cases, you will find that the home buyers have paid the money and are waiting for 10 years, 15 years, they have not got their house. As even rightly pointed out, they are paying EMIs and also rent elsewhere. Now, this again is a great outflow on them. In addition, not only they have to find the balance to get their houses, they may have to also bear escalation cost. These are very pain points in a resolution which needs to be addressed. So handling the home buyers is a very sensitive issue. We need to understand their concerns. They will throw their ire and anger at you. You are the AR for them. Communication is the key. Communication about what needs to be done. One good thing that has happened in the recent amendments in IBC is that earlier the representative of the home buyer, the authorized representative, was more or less just like a courier. He has to take the notice, send it to the home buyers, get their feedback, give it to the COC, and vote based on what they are deciding. But now in the recent amendment, the IBC has been changed, and there is a pre-COC and a post-COC meeting that has been decided upon. Now this gives the AR a communication opportunity either through a physical meeting or a VC, where he is able to communicate what is the agenda, what is the purpose of the agenda, what are the options of decision making in that agenda is one thing that can be appraised to them before the meeting, take their feedback, and communicate to COC the concerns and the suggestions of the home buyers. That is one. Once the meeting is over and the minutes are circulated, then there are voting items there. Certain decisions are taken. The AR convenes a post-COC meeting and conveys to the home buyers the decision taken, the reason behind the decision, the issues that has come up, and also seek their suggestion, how it affects them. Second, he can also guide them also how to vote on the resolutions, what is the benefit of voting for it and voting against it, and explain why it has to be done. More importantly, you have to basically encourage them to vote. Typically, I will tell you one of the processes where I am an AR. Though there are 60, 70, 80 home buyers, typically 3 or 4 used to vote on the resolutions. After this process of talking to them regularly, now there are about 16 to 20 of them are voting. So the numbers will increase as and when they realize that to ensure that their rights are protected, they need to come and decisively vote is something that they've realized. And that is a singular responsibility of the AR to take it forward. But he is the person who is largely in touch with them. And he is the bridge between the COC and the RP and the home buyers. So that is the key requirement. And that is how the home buyers could be managed given the current situation.
I think this will
Yeah,
very, very
yeah.
helpful.
Yeah, Mitesh, if I can just add a few of experience where I have been AR. I have been AR in more than 6, 7 companies so far, and you need to explain each and everyone at every point of time the rights of their home buyers to them, and there are situations where SRA has SRA authority, slum rehabilitation redevelopment authority. They have already taken up the entire assets, and still what has left is nothing but development right which has been taken over by SRA. So there is no practically there is no development. Only the money which has come from home buyer, and on the asset side there is nothing left. So in such a scenario, even we need to explain the resolution applicant also that if you will not favor the home buyers, in that case you may lose this particular company. So in that case also people have agreed to give them some amount, say 80%, 70%, and likewise it has been resolved amicably. Even the home buyer also has to understand when there is no assets existing, whatever the rights were there were taken back by the government authorities. In that case, the practically the purchaser is not purchasing anything, but is just meeting all the liabilities of the company. So in such a situation also there has been win-win situation, and people have agreed to accept the amount of say 80% or at the rate of 80% whatever they have spent, and then they give willfully they have given their consent for go ahead in the project. So this is how it has been resolved in one of my cases.
Great, great. So I think a lot of angles are coming up from RERA to SRA to multiple other legal tangles and issues with regards to arrangements like development rights and ownership rights and multiple other models in which the financing and the structuring of the deals happens in real estate. It is really, really complicated, and lot of knowledge is required to be achieved by the insolvency team, be it the legal team, be it the main CIRP team, or you can say the process team, and also the deals team, because it is always a complicated matter. So whoever is going to buy or whoever is going to be interested to acquire this running company, or maybe projects into liquidation, whatever may be the format in which the resolution happens. In either cases, the parties have to sit across, spend a lot of time, see what are the claims, how the structure has happened, what is the actual right of the company that is under CIRP, what are the payouts that they have done, how these issues will be resolved with respect to other authorities like SRA, RERA, authorities like GST, income tax, multiple authorities will participate in the process, and how we will be able to see the resolution coming through, and the home buyers and all the stakeholders feeling happy about whatever they have done, maybe receiving 80%, 60%, whatever. But ultimately, the project seeing the light of the day and things moving in right direction, that is the expectation of the government. And that is why IBC is there for actual resolution of projects. So we will go to the question to Hemant Bhai again. We will ask him how he handles in real legal terms and process terms the stakeholders like the erstwhile directors, or you can say promoters of the company on one side, bankers on the other side, the operational creditors on the third side, and home buyers. All, of course, Devarajan ji has thrown a lot of light on that. So how he handles this in the practical scenario, and how he actually keeps everyone happy while the resolution is happening, because it is a big challenge and it is big pull and push between all these parties to jeopardize the interest of the other while achieving their own interest, and how this actually happens, Hemant Bhai. So please throw some light on that aspect.
Yeah, see, Videsh ji, actually, I have seen about more than 10 companies CRP process so far, either as a registered professional or as an process advisor or as an representative to home buyer. So, here the typically promoters is the person who is always the majority of the time are not non-cooperating or people, class of people. who don't like, he has controlled the company, he has, formed the company and he has run it for more than 10%, 10 years or say 20 years. And now somebody else is controlling the entire show. So he is the always unhappy class of people who are not, readily accepting that now because of their management and because of their, particular circumstances, the company has gone into CARP process. So it is very difficult for us in majority of the company to explain the promoters and seek their cooperation. In few companies, we got the cooperation from the existing promoters, but in majority of the company, we could not get the cooperation, and there is always a information which are not been shared with the RP or the RP team, and RP has to work without any information. Basic information also are not been shared. So all these things has been trackled, you know. So we always try to persuade the promoter. Company has already been under ICU. You have to help him out to the company to come out of ICU, and you can, definitely contribute to that extent. But somehow promoter is an unhappy community. Secondly, home buyers are also, as I have said earlier, they are also unhappy people where they have invested their life savings and their dream house is already under, pending status for more than 10 to 8 to 10 years. So they are also to be pursued, that now their waiting will be definitely, we are trying to cover the entire situation, and we will definitely try to convert their dream into reality by giving them homes. But in that case, the haircut and something which is called a haircut, where they have to also accept the situation because the promoters have already run out away with certain chunk of money, or they have misappropriated, or their decision went wrong in that direction, and the company lost more than about 50 to 80 or even sometimes 90% of their total accumulation of reserves and funds. So everyone is ready to should be ready to take a haircut. And likewise, we explain to home buyers as well as we explain to financial creditors in this situation. Here, the financial creditors are also, it is upon always a majority game where 66% or more voting power will play a majority role for decision making in any of the resolutions. So all the people who are holding more than 66% voting power, majority financial creditors as well as home buyer also sometime. Okay. So all them has to be pursued with, we have to just pursue them and, bring them on the same table where this can be resolved. And real estate cases are, majority of the problems are related to lands where the title of the lands are not clear, or development rights are not clear, or the company has been, there has been a mortgage created on the land earlier. And so many litigations are going on in the particular sector. So you have to be very careful, and all the stakeholders should be informed about the factual position of the company and try them to bring it on the same table.
Yes. I would like to add to this one or two points. See, it's something like this. What we need to understand is a very simple aspect: the promoter's psychology. The promoter is losing control of his company. So the first thing he does is to safeguard himself, to protect his interest. Automatically, when he protects his interest, he will not cooperate with that. So basically, it is the RP to communicate to the promoter and say that by cooperating, you are going to increase value. There are a lot of things which where there are hidden values are there, which can be tapped and realized. And this will ensure that the project maximizes value. Now, what is the advantage in maximizing value? You will say, when that I'm losing the company, the company is not in my control. It's a different issue. It's a different aspect that he'll be able to pitch for the company, submit a plan, which we don't know. But the fact is that the more and more value is realized, then when the lenders recover more and more money, there will be less pressure on his personal guarantee. And he may not face personal insolvency issues in a very serious way. And normally lenders, when they find that the promoter is cooperating, is trying to create value, they will also be soft on his personal guarantee and try to settle it much better. So the issue of non-cooperation that most of the RPs want to file to safeguard their interests, my view is that I normally talk to them and I will finally do a non-cooperation if only there is no other option, then go for a non-cooperation application. We all know a non-cooperation application also is not too effective. An order is passed by NCLT, but ultimately the promoter doesn't share. You can have a contempt, you can have penal proceedings against the promoter, but your job is not done. If you take a statistics, you'll find where there is non-cooperation, those processes have taken a longer time to resolve. One, and have got lesser value. Now, the second issue that we need to understand is that what is the promoter's concern? The more information he shares, he is worried that the RP will try to find avoidance transaction, file cases against him for recovery. So this is also a practical issue. Now, balancing it out is a very tough job for the RP. So the RP has to really understand that what are the transactions where the intention of the promoter was not, and only flag off those transactions that avoid transaction. In businesses, people do certain things with the interest to ensure that things turn out the right way, not with the interest to, harm the company. Of course, there are certain promoters who siphon off funds. That's a different story. That is dealt differently. Now, that intention part of a transaction needs to be understood by the RP sitting with the promoter on a one-to-one basis to understand why he did that. Because in an avoidance transaction, if the intention is clean, the intention is nice, the NCLT is lenient towards it. These are aspects that needs to be explained to the promoter so that he participates actively in the COC to maximize value. This is one aspect that we need to understand. And the RP plays an important role here by comforting the promoter that I have no interest in filing cases against you, but I have to do my job. If you assist me and we work together, we can do a better job of it. Some promoters accept it, some promoters don't accept. So I've seen both in the process I have handled. I can only tell you that in 4 or 5 processes that I've handled, I have filed only non-cooperation in one process. In none of the other processes I have filed non-cooperation. I managed without filing a non-cooperation. So this is something that we all need to understand. It is not about RP protecting himself by ensuring that he has filed a non-cooperation. What can I do? It is about the RP proactively ensuring that the promoter cooperates. That is why the deterrent section is there, that in case he doesn't cooperate, you file non-cooperation. It is not the other way around, that you file a non-cooperation to ensure that he cooperates. So this is a very important aspect of the promoter's angle, and RP can try it out. It may add value to the whole process.
Super.
Just one small clarification. Avoidance transaction means preferential transaction, undervalued transaction, or fraudulent transaction, or erroneous transaction. So these are the 4 category of transaction where promoter has when they are realizing that now ship is sinking, and then they are trying to make the money from other sources like this, take out the money from the company. So these are the avoidance transaction. Just one clarification.
Yeah. Very useful. I'm sure a lot of promoters would learn from this video, and they will take this video positively, because already they are into a situation, whatever may be the reason, sometimes statutory changes, sometimes luck, sometimes bad business decisions, sometimes some other wasted interest coming in the picture and creating a problem. Multiple situations can be there, but now you are already in a situation. So please act in the tandem with the wave that is going on. Work in a team and solve the problem. Let's go to the last question with regards to this for Shanti Bhai, who is been a builder, developer, and a contractor over a period of so many years. Seen lot of projects from other side of the table as a promoter, as a owner of a company, as a director, as a CEO, and now playing role in this team for seeing how the resolution can be smoothly done and how each stakeholder is kept happy while the resolution is happening, while everyone is pulling for his own benefit, how we can solve the problem together. So Shanti, my first question is, who are possible buyers, or you can say who are possible people who can file the plan, or you can say the EOI for such scenarios, and why would they be interested in buying such sinking ship or the problematic proposals in the real estate industry?
Thank you, Mitesh ji, for inviting me and giving me the opportunity to participate in this panel discussion. As rightly being pointed out by RP, our Hemant Mehta and Devarajan sir, that since this CIRP process, as we say, this is a being resolution process of the company which has gone, and financially their targets have not been achieved properly, and company has gone into the NCLT. So the real estate sector is concerned, housing and this real estate sector is being concerned, we widely see these companies are entering into this NCLT. So nowadays, it is the other way opportunity for the so many players in the market, because many companies would have experience of getting the things and properties relieved from the court procedure or some DRT procedure. But here in this IBC, the procedure is little bit different as respect to the transfer of the rights of the property, that is the title of the property. But at the same time, as rightly being pointed out by Devarajan sir, compared to other processes, this process is quite speedy. Yet it is a slow going process, but it is quite speedy than the other process. So in the present market scenario, there are a lot of opportunity for the players, that is the promoters, builders, developers, and the contractor profiles builders also, that they can have the good opportunity to buy such company and the properties, because in this process they can offer their resolution plan, they can participate in the EOI process, and there is a smooth and very clear process by which they can participate once they are fulfilling the eligibility criteria. So it is a defined process, as rightly being pointed out, 270 days process. Sometimes it get extended, that's other way scenario. But bit cheaper rate properties are available. And at the same time, you are resolving the company which has gone wrong due to the mischief or some wrong failures and plannings by the developer and promoter. So in all, you are resolving the matter for the suppliers, that is the creditors of the company, money lenders and the service lenders, and these other home buyers also, because it is very much good opportunity for participants and the players of the market to participate in this CRP process and get the things at their good price.
Who all can participate? What is the process flow that they have to follow to participate in this process? And what is the cost or risk involved if they can't manage to sail through the process? Shanti bhai, again for you.
I think from perspective of the developer and the promoters in the real estate sector, IBC is concerned, it is bit very easy and the smooth selling process. Because once the RP declares these EOI and publishes in the various medias in the public domain, they have to apply, and the criteria are being laid down in the EOI itself. Whether your company is fulfilling those criteria, then you are eligible to participate in the process with the due and set deposit amount, which is being kept by the RP till the process runs. And the process is being simplified, that EOI is being floated. Resolution professional invites the resolution plans. But before that, EOI, that expression of interest, is being invited from the various players in the market. So one can participate in this process, and one can wait for date to be declared as a resolution plan. So they can very well study the process. And then RP declares all the company details over the, say, some sort of data room is being created in which you are given the opportunity to see the data, download, analyze, and you can ask the queries to the team RP. RP is having all the information with him, because over a period of time, he has gathered a lot of information regarding the projects, properties, and various development rights, or that may be projects involving Mahada or SRA or different forum projects might be there. Some redevelopment projects might be taking place. So in the portfolio of the CD, that is corporate debtor, there can be various projects. So from opportunity point of view, sometimes you can participate for the particular cluster in which you are interested. There may be some land parcels, then unfinished projects in which home buyers are being given the homes, and then there are various contractors who are working and who have rendered the services. So you have all the data and information that is being given from and provided by the RP. So based on those information and your study from the projects and the market, you can quote your price at the right time when the resolution plan are being invited. So this is a very simple process. If you are not selling through, then you are given with your deposit return. So in all, you are participating and you are getting very fine response in the process. So one can easily go for the process in the participation.
Correct. So what all?
One point I would like to add here, if it is okay with you, is that the only thing is that if you evaluate legal challenges in any real estate project, they're very complicated with so many agreements, so many arrangements. Those needs to be understood correctly, and also understand that what kind of reliefs NCLT can give and what they cannot give. Because, for example, pre-existing contracts have a sanctity. You cannot wish them away. But at the same time, the pre-existing contracts needs to be completed, or it has to be renegotiated with the SRA so that his plan becomes viable. Then like that, there are many issues we can go on and on. But that is one challenge that needs to be evaluated by any developer who comes into a NCLT project, where there are a lot of complications and risk in terms of litigation that are pending in various forums. That is one point I'd like to add. Thank you.
At the same time, I would like to emphasize that, sometimes people are getting very good deal, which otherwise they would have lost by paying, say, more than about, say, 100 rupees worth of product they are getting at 50 rupees or at 75 rupees, and they are making good money. But there are investors in the market who are in this field, who are expert in the stressed assets business, and they are day in and day out purchasing all the stressed assets, and they have very good team with legal team as well as other teams who can assess the risk inbuilt in the particular project, and accordingly they are making good money out of it.
Correct. So I think we can sum this up now. We can say that a lot of projects get into challenges due to different reasons: financial and non-financial, planning reasons, political reasons, and multiple other authority changes, legal changes, reasons. And once they get into it, there are a lot of stakeholders like contractors come into the category of operational creditors, or even the suppliers of cement, steel, and major raw material go into category of operational creditors. Then there are home buyers who are now classified as financial creditors and have got a lot of weightage, because home is considered to be the life saving of the home buyer. So they have been given a lot of importance. A cluster of home buyer or all the home buyers in a project come together and make it as a as a combination with an AR, that is authorized representative, who will actually advise, guide, and represent them in all the committee of creditors, that is COC. Then there is a third very important stakeholder who generally plays the shots, that is the banker. and financial creditors, whoever, there can be multiple bankers, single banker, there can be financial institutions, there can be ARCs like Edelweiss and others who can be financial creditors sitting on the COC. So these people also play a very, very important role and play the shots. Once the process is carried out, someone like Hemant Bhai, who is a resolution professional, actually plays the role of handling and completing projects which are in incomplete form, convincing various stakeholders, working with them. There are legal experts like Devarajan ji who actually play the role of guiding people who are actually the resolution professionals like Hemant Bhai. They can also be ARs who can be like authorized representative in various cases and guide the home buyer. They can also play the role of legal consultants to handle multiple complex matters going on against the corporate debtor, that is CD, and solve those matters within the span of 180 days, 270 days, or extended period, whatever court allows them to offer. And then once the situation is there where actually the EOI is floated, things are moving smoothly, the IM is ready, all the data is ready, collected in the data room, then the EOI process starts. The initial bidding stage happens with all the qualification, net worth, etc. Criteria is fulfilled, and people like Shanti Bhai play a role of marketing, explaining people as to how to handle, how to manage to participate, how to take care of consortium model and other models, and which cluster to participate, which is beneficial, which is not beneficial, which has what challenges. And again, in that process, people like Devarajanji actually guiding and helping them prepare the final plan for submission to the COC and convincing the COC that they are capable and they will solve problems of home buyers, also financial creditors, and they will give systematic exit to everyone in the process and take care of everyone. So that ultimately happens, and then the CD sees the light of the day and gets the final resolution. There are only 20 to 30% cases which reach this stage. Most go into liquidation over a period of time. The most of the reasons that I could think of in my understanding of being in the process in various time frames is communication gap, teamwork, and vested interest play a great role in killing the CIRP process, and things go haywire over a period of time. So if everyone teams up, the RP, the legal consultant, the AR, the bankers or financial institutions, financial creditors, operational creditors, and decide, and of course take the help of promoters to get all the information, then things can happen wonderfully well and everyone can be happy at the end of the day. So this happens very rarely, but this is what the government aspires, and we all aspire that this happens over a period of time. Through this discussion, we wanted to reach out to you and tell you that here is an experienced team who can help you solve a lot of issues. If you are into any of these situations, and also, you can follow us on our YouTube channel because we are planning to bring in various detailed aspects of this. For example, the CIRP process details, the legal process and legal hurdle details, home buyers is a big area where we can focus on, maybe one session on home buyers. And then, of course, ultimately the EOI process and the resolution plan process, and ultimately final handover process, how it happens. So we will take one step at a time. Hope this was interesting and useful for all of you. Please feel free to share with right people, relevant people who would be wanting to know more about the process and how it happens. And also like and share our YouTube channel and subscribe it for seeing more videos on this topic. We will create a play, what you call a playlist for you on IBC with specifically focused on real estate and construction and similar projects over a period of time. Thank you, everyone, and goodbye. Thank you, Devarajan ji. Thank you, Hemant Bhai and Shanti Bhai for
Thank you very much. Thank you to all of you. Thank you.
Thank you, everybody.